Hey everyone, and welcome to today's Explainer. We are diving straight into a highly debated and, frankly, incredibly complex topic today. We're going to be objectively unpacking a recent reaction from YouTuber Isaac Butterfield, where he analyzes a landmark ruling in the Australian Federal Court. Now, this source material is passionate, it's controversial, and it really strikes at some fundamental questions about how society and the law operate. My goal here isn't to take a side, but simply to guide you through these arguments exactly as they are laid out in the source. So let's get right into it.
At the absolute burning center of Butterfield's video is one fundamental question. Does the law view sex as a biological reality or as a mutable identity? We're looking at a direct collision between traditional biological definitions and modern legal interpretations here. The source argues that a recent court decision has fundamentally shifted the answer to this question in Australia, literally reshaping societal norms in real time. And whether you agree or disagree with the outcome, understanding these legal arguments is absolutely crucial, because frameworks like these often serve as test cases for policies that impact our everyday lives all across the globe.
Here is our roadmap for today. We'll start with the Giggle app dispute, examine how the court defines sex in law, and explore the societal impacts Butterfield predicts. Then we'll trace the 2013 legislative roots, contrast Australia versus the UK, and look at the ongoing legal battle.
Section 1. The Giggle app dispute. A social network and a lawsuit.
Okay, so the premise of this app, which was created by Sall, was pretty straightforward. It was meant to be a female-only social network. According to the source, the whole intention was to provide a safe, digital space for women to chat, organize, and discuss female-specific topics without any unwanted male attention. And to actually enforce this, the app utilized something pretty surprising: facial recognition software. And honestly, it worked. By 2021, it had scaled up to 20,000 users across 88 different countries. It was explicitly designed to be an exclusive, protected community.
But then, the conflict really accelerates. In 2021, a trans woman named Roxan Tickle was removed from the app for not meeting that biological female requirement. The following year, in 2022, Tickle filed a complaint with the Australian Human Rights Commission. Now, Butterfield highlights a specific detail here. He notes that Tickle allegedly had access to a $50,000 legal fund tied to the University of New South Wales to pursue this case. Fast forward a bit to August 2024, and the federal court officially rules against Sall and Giggle.
And here's where Butterfield really zeroes in on the financial penalty. You see, the judge didn't just rule against Grover, the court ordered her to pay damages that were doubled to $20,000, plus all the legal fees. Butterfield expresses intense outrage over this penalty, especially noting that Grover had already spent millions on her own legal defense. He characterizes this ruling as a massive kick in the guts for a woman who felt she was just trying to build a space for other women.
Moving to Section 2, defining sex in law. The court's ruling.
The really crucial point to understand here is exactly how the court categorized the app's actions. The federal court didn't view this as some sort of legal gray area. Not at all. They found two clear instances of direct discrimination against Roxan Tickle under the Sex Discrimination Act. For Butterfield, this right here is the seismic shift. He argues this establishes a brand new legal precedent that effectively redefines biological sex in the eyes of the law, basically making it illegal to exclude someone based on their biological sex if they identify otherwise. To underscore the government's stance on this, Butterfield points to a very specific statement from Anna Cody, the Sex Discrimination Commissioner. When she was asked to define a biological man, Cody responded that she is not a medical expert, stating exactly this: "The Sex Discrimination Act does not define man or woman. It has an inclusive definition of women that includes all women, trans women, lesbians, women with disability." Butterfield expresses immense frustration with this answer, arguing that the very people tasked with protecting sex-based rights are refusing to define biological reality.
Section 3. Butterfield's predicted societal impacts. Extrapolating the precedent.
So Butterfield vehemently argues that this legal precedent is going to compromise environments that many of us just take for granted. He specifically lists out public women's bathrooms, female sports leagues like hockey and rugby, and highly sensitive spaces like domestic violence shelters. He states, quite neutrally in his setup, that while most transgendered individuals are simply living their lives, the physical realities of biological males, things like size and strength, present a fundamental unfairness in sports and a potential loss of safety for biological women in those vulnerable spaces.
Ultimately, Butterfield summarizes his core fear as a clash of definitions, a legal reality that completely overrides biological reality. In his view, the law now dictates that a chosen gender identity takes total precedence over biological sex. He argues that laws like the Sex Discrimination Act, which were originally designed to protect biological women, are now ironically forcing those very same women to share their protected spaces.
Section 4. The 2013 Legislative Roots. How did we get here? Interestingly, Butterfield traces the root cause of all this back over a decade. Back in 2013, under Prime Minister Julia Gillard, the Sex Discrimination Act was amended. And Butterfield emphasizes this point heavily. Gender identity was added as a protected characteristic without a public referendum. The Australian public never directly voted on it. Then, 11 years later, that specific amendment, which had essentially laid dormant, was successfully utilized to bring down the female-only Giggle app.
Section 5. Contrasting Australia and the UK. A global divide in high courts. Now, this is a fascinating comparison because it brilliantly illustrates the global divide on this issue. In 2024, the Australian Federal Court interpreted their act to mean a female-only app is discriminatory if it excludes trans women. But meanwhile, around the exact same time, the UK Supreme Court ruled unanimously in the Women for Scotland case that the word woman strictly refers to a biological woman. Butterfield points to that UK ruling as completely ambiguous, stating his belief that the UK is on the right side of history while Australia is heading in the complete opposite direction.
Section 6. The ongoing legal battle. What happens next?
To really capture the sentiment of Sall Grover's defenders, the source highlights a quote from Robert Clark of the Alliance for Defending Freedom International. He says, "A law written to protect women has been used to punish a woman for creating a space for women." This perfectly encapsulates their central grievance, doesn't it? It's a perceived paradox where a legal framework designed to shield a marginalized group is seemingly being weaponized right back against them.
And because of that strong grievance, we are seeing a lot of active resistance from key figures. Sall Grover refuses to back down. She is actively appealing the ruling all the way to the High Court of Australia. On the political front, Pauline Hanson is backing Grover's cause in Parliament. And commentators like Isaac Butterfield are utilizing their platforms, including his upcoming national tours, to rally public support over what they see as a critical loss of women's rights.
Which brings us to the ultimate, unresolved question of this explainer. If the High Court actually upholds this ruling, what precedent does this set for our future? If the legal definition of sex is entirely decoupled from biology, how is society going to navigate the boundaries of sports, shelters, and private spaces globally in the decades to come? It is a deeply complex, incredibly emotional issue that is literally rewriting the legal landscape as we speak. Thank you so much for joining me to unpack this today. Stay curious, and I'll see you in the next explainer.